Hello and welcome. I'm Amritanshu Rai and you're watching Law of the Land on Raj Sabha TV. Today we bring to you the Fugitive Economic Offenders Bill 2018. The bill seeks to confiscate properties of economic offenders who have left the country to avoid facing criminal prosecution. To discuss the issue, I have with me Mr. A.K. Bhattacharya, Editorial Director, Business Standard, and Dr.Abhishek Atrey, Advocate on Record, Supreme Court. But before we go on to the discussion, let's look into what all the bill has. The Fugitive Economic Offenders Bill 2018 seeks to confiscate properties of economic offenders who have left the country to avoid facing criminal prosecution. The cases where the total value involved in such offences is rupees 100 crore or more will come under the purview of this bill. Rich and influential businessmen like Nirav Modi and Vijay Mallya defrauded Indian banks and then fled abroad to avoid arrest. These are not the only cases, but there have been several cases of economic offenders fleeing the jurisdiction of Indian courts. The absence of such offenders from Indian courts obstructs investigation and wastes precious time. Most cases of economic offences involve non-repayment of bank loans, affecting the financial health of banks. The existing laws are inadequate to deal with the severity of the problem.
It has certain criteria. So number one is the offence committed by that person should be from the schedule offences, which are attached with the bill. There are 54 sections pertaining to 15 acts. Number two criteria is that the quantum of offence should be more than 100 crore. The third criteria is that a non-bailable warrant of arrest should have been issued by the criminal court in India against him. Number fourth criteria is that person must be evading his presence in the court to the warrant of arrest by being abroad. That is, either he has left the country while the offence was being investigated, or he left the country even prior to the offence was being investigated. He was abroad and he refused to come back to join the investigation. Such person is considered to be a fugitive economic offender.
The Fugitive Economic Offenders Bill 2018 defines an economic offender as someone against whom an arrest warrant has been issued for committing any economic offence under the law. Person who has left the country to avoid facing prosecution and refuses to return to face prosecution. Some of the offences listed include counterfeiting government stamps or currency, check dishonor for insufficiency of funds, money laundering and transactions defrauding creditors. The proposed law empowers a director or deputy director level officer under prevention of money laundering to file an application before a special court to declare a person as a fugitive economic offender. The application will contain the reasons to believe that an individual is a fugitive economic offender, information about his whereabouts, a list of properties believed to be proceeds of a crime for which confiscation is sought, a list of Benami properties or foreign properties for which confiscation is sought, and a list of persons having an interest in these properties.
A director will be appointed under this bill, then he will file a case in the special court where he has to prove that he is a fugitive, as well as available properties under his crime, those will be identified, and within 15 days the government will, the special court will send the notice to the address of this person in the foreign country, and this is the duty of the director to identify where he is living, and the person is supposed to be, and he has to come back to the India and to attend the court proceedings. But there is a provision that in between, if before he has been declared the fugitive, he can come back to return to India, and the normal civil procedure will be available to him.
The bill is expected to re-establish the rule of law with respect to the fugitive economic offenders, as they would be forced to return to India to face trial for scheduled offences. This is likely to help banks to achieve higher recovery from financial defaults committed by such fugitive economic offenders. The Fugitive Economic Offenders Bill 2018 was introduced in Lok Sabha on March 12, 2018 by the Finance Minister Arun Jaitley. With Nishtha Malhotra, Amritanshu Rai, Rajya Sabha TV.
So the purpose of the bill is largely to create a compelling environment for all fugitives who defraud or indulge in economic offences and abscond. So people who have absconded need to be brought back. In order to create that compelling environment, the Fugitive Economic Offenders Bill has been brought about. My question to you, Mr. Atrey, starting off is, so you just saying, just in a while ago, that the public or the victim does not have any role to make a petition before the director or the special court if he is suffering because of someone absconding and running away.
This part is lacking in this bill, in my opinion, because in most of the cases, ultimately it is the public who is being cheated, and for the benefit of whom this kind of legislation is brought. But only government, only director or deputy director has a right to initiate proceedings. Public has no role to initiate these proceedings. The proceedings can be initiated by director or deputy director only.
So what you're saying is that it is between one part of the government to the other
government
part
and the offenders. It's an affair between government and the offenders. So if government want, they can initiate proceeding and they can bring him back. So if government don't want, no proceeding can be initiated. In the public, the victims who are being cheated, they can't compel the government by any mode.
So can the public or the victim not approach the government? For example, what you're trying to say, if I've understood it correctly, is if I am the person who's been cheated of 200 crores, I'm an individual, not an institution, and I am the victim and I need my money back, and the man has absconded, is a fugitive, right?
Correct.
So I need to go and get him back. I cannot petition.
You cannot file any petition.
But can I petition the government?
God.
Will that have an impact?
No, there is no such provision in this. There is no such provision in this.
Yeah, Mr. Bhattacharya, you're trying to add?
My sense is the director is pretty powerful here. The new institution of the director is pretty powerful. And my sense is that when the rules are framed, director will be within his powers, technically, to accept applications from people to initiate such cases. Now, what does the director do? He doesn't go out on a fishing expedition. He is also waiting for complaints from people.
Yeah.
Now, once the director is empowered to initiate these cases, my sense is that the people who think, people like you said that you have been defrauded of 200 crore. Now, you will be within your right to approach the director, which is in office. Now, it's like a director of investigation.
Actually, he's already empowered.
He's empowered.
He's
so
already
he can
empowered
take up the case
to accept
and say,
petitions.
listen, this guy is complaining, this is the case, and if it is a fit case, now he may move to the special court with those, and the powers of the director are pretty tough.
Huge, yeah.
Huge powers.
Huge powers.
Even before he actually issues a notice, he can actually attach the property.
Correct.
So that's a very, very strong power he has got. So I feel that the director, the creation of this director is actually the centerpiece of this legislation, where he's very, very powerful.
So there are 15, so just coming to you, Dr. Atrey, so there are nearly 54 sections and 15 acts that have been scheduled. So under this, in that, the director already probably has the power through some of the other act to receive petitions, and act on it.
Yes. Everywhere prosecuting agency, director is ultimately a prosecuting agency.
Yes.
We have to approach in normal cases. If you see where public goes to police station and police don't register FIR, then what to do? You will file a petition under 156(3) before court to initiate those proceedings.
Correct.
But this is not here.
So you are saying that it is missing in this proposed law?
It is missing in proposed law.
And would it have helped if it was like specifically codified and written that way?
Yeah, definitely it will help.
Okay, now going to the next point, so the 100 crore is the limit that the bill provides, 100 crore or more, and any offence relating to that with the person being a fugitive, that is where the bill kicks in and the powers kick in. So the point that you were making, that even less than 100 crore, how does it come under the ambit, or is it supposed to be tackled in the usual civil
Yes, the stage
manner?
thing which when I was reading this act, in statements of object and reason, the 100 crore criteria is given. But when we look into the definition of fugitive offenders, there is no such criteria of 100 crores. Therefore, in my opinion, at appropriate stage, it can be interpreted like this, that even persons where fraud is below 100 crore can also come within this
ambit. Do you get
Yes.
the same sense?
Well, you know, my sense is that the director will be inundated with all kind of cases if the threshold is lowered, or if the scope for lowering the threshold is kept like that. I think the purpose of this bill is also to catch the big fish.
Yeah.
So if you bring it down below 100 crore, my sense is this is one director and probably a deputy director, and there is a special court. Given the situation of how our institutional capacities are actually not adequate to take care of the number of cases that are coming up before the courts, my sense is to lower it, and given the option of lowering it below 100 crore will probably defeat the larger purpose of catching the big fish. Remember, there are 15 laws that are covered under those offenses.
Yes, yes.
I mean, you know, as simple as dishonoring a check, as you are pointing out.
Correct.
And even defrauding credit, even under the Foreign
Yes.
Contribution Regulation Act is been covered under this. So it's a comprehensive thing.
Yeah.
So my insider trading is covered under it.
Correct. It's
So dishonoring of checks. So all those things are there.
Section
So
447.
so if you bring it down to 100 crore, my sense is that you will be, sort of snowed under work, and the real culprits probably will get away very easily.
Get away. Another point to you, Dr. Atrey, is so if a person comes back before he is declared an offender, what happens then? So the bill clearly states that the proceedings will stop and he will carry on with the civil suit. So if he joins, after absconding, if he joins the proceedings, that is what it says. But you have a different take on this.
Yes, there are two provisions. At one stage, it says that as soon as the offender comes and appears before the special court may terminate the proceedings. The word may is used. It is not shall. So it is discretion on the part of a special court to stop those proceedings there. On the other hand, under section 12, it specifically says that after hearing application under section 4, which was filed by the director or deputy director, they can go further and declare that person fugitive offenders, and thereafter under next provision 12.2, they can declare all the properties which were attached previously, to confiscate these properties. And when they pass an order to confiscate these properties, they shall vest in central government free from all encumbrances.
So all
And
you are
the
saying is that the termination
he may or he may not be acquitted at this stage. His problem is not over as soon as he comes here.
and there is an ambiguity there.
Yeah, ambiguity there.
Ambiguity
The
there.
scope is there. We are not going to leave you whenever you come or you don't come.
Well, do you think that's a deterrent?
I think it's an important point that Mr. Atrey is raising here. I think there is scope for interpreting it that way, and if that happens, in my view, the
compelling
larger,
environment,
the larger intention of the legislation will probably be compromised, because as I said, that the director is a very powerful body. You know, I mean, remember, even without doing anything, if he thinks that there is an absconding guy and his property is here, he can actually attach that property for 30 days.
Yeah, without
giving anything, just before he files
without
the notice.
any permission. Yes,
without permission. So it's so may and shall are very important words under these circumstances.
It's time for us to head into a break. When we come back, we will tell you about the powers of the special court and also the director.
जली को आग कहते हैं, बुझी आज तो उससे कह देना
अभी तक वो चाकू तैयार नहीं हुआ है जो
वो सौगंध पूरी नहीं हुई।
चिल्ला चिल्ला कर कहेंगे खामोश।
कि हिंदुस्तान के अखबार नहीं बल्कि शायद दुनिया के बड़े बड़े अखबारों में आने लगा कि पहली बार कोई विलन पर्दे पे आता और पर्दे पे आते ही इसका पब्लिक जोरदार तालियों से स्वागत करती आता, तो ऐसा कभी नहीं हुआ। मैं विलन बनना नहीं गया था, मैं एक कलाकार बनने गया था जिसका विस्तृत रेंज हो। रेडियो में भी हमने कोशिश की रेडियो में जाने की, तो एक रेडियो प्ले में मुझे इजाज़त तो मिली, मैं गया तो सही, लेकिन उसके बाद समझिए कान पकड़ के निकाल दिया गया वहाँ से कि आज के बाद रेडियो स्टेशन को दोबारा मुड़ के देखना मत।
गुंडा राज का खात्मा वही कर सकता है जो स्टेट का सबसे बड़ा गुंडा है।
नमस्कार, मैं शत्रुघ्न सिन्हा बहुत जल्दी मिलने वाला हूँ आप लोगों से प्रोग्राम गुफ्तगू में,
सिर्फ राज्यसभा टीवी पर।
Welcome back. The Fugitive Economic Offenders Bill provides for attachment of property. The director may provisionally attach any property without permission of the special court, provided they file an application before the court within 30 days. The special court is empowered to confiscate properties in India and abroad.
If at any point of time before any person is declared an offender, the alleged fugitive economic offender returns and submits to the court, proceedings under the proposed law will come to an end. All necessary constitutional safeguards in terms of providing hearing to the person through counsel, allowing him time to file a reply, serving notice of summon to him in India or abroad, and appeal to the High Court have been allowed. Provision has also been made for appointment of an administrator to manage and dispose of the property which has been attached.
Previously, we had the Prevention of Money Laundering Act, which permits attachment of the properties which are proceeds of crime, whether in India and abroad. But his own property, suppose that person has his own properties at various places, that was not possible to be attached. There is a similar provision in CRPC under section 82-83 of that act, which gives the provision of proclaimed offender. If the person is not joining investigation, whether he is India or abroad, and he is not traceable by the investigating agencies, then he can be declared proclaimed offender and his properties can be attached. And that property attached should be in India only. This act provides that attachment even beyond India. Second most important is that it provides that such person who is a fugitive economic offender cannot institute or participate in a civil case in India.
The Fugitive Economic Offenders Bill also provides for attachment of property. The director or deputy director may attach any property mentioned in the application with the permission of a special court. These authorities may provisionally attach any property without the prior permission of the special court, provided that they file an application before the court within 30 days. The attachment of the property can continue for 180 days unless extended by the special court. If at the conclusion of proceedings, the person is not found to be a fugitive economic offender, his properties will be released. After hearing the application, the special court may declare an individual as a fugitive economic offender. It may confiscate properties which are proceeds of the crime, are benami properties in India or abroad, and any other property in India or abroad.
Running away from India is not so simple. He loses all his rights when he runs away from India. And once this property is confiscated, it goes for all time to come. Earlier people were thinking that I run away and when I come back I will acquire my property back. Now once this declaration is made under this act and the person is declared as a fugitive economic offender, all his property, proceeds of crime will vest in the custodian. and that custodian will distribute the property to the person to whom it belongs to. So whenever he comes back after India also, then he will not be able to get back those property because those property have been confiscated and utilized also. So this is going to firstly help in putting pressure, secondly helping those people to whom the property belong, the money belong, to get the money back. That's the biggest advantage. It will help it out.
Upon confiscation, all rights and titles of the property will vest in the central government. The central government will appoint an administrator to manage and dispose of these property. The bill allows any civil court or tribunal to disallow a person who has been declared fugitive economic offender from filing or defending any civil claim. The director or deputy director will have the powers to enter a place on the belief that an individual is a fugitive economic offender and directing that a building be searched or documents be seized. With Nishtha Malhotra, Amritanshu Rai, Rajya Sabha TV.
The proposed law also specifically mentions that the offender or the fugitive will not be allowed to participate in any civil proceeding relating to defending his property. That's a big right that is sought to be withdrawn from an Indian citizen. And that's where we come in. Mr. Bhattacharya, do you think that's an important, very, very relevant exception to make?
Well, you know, I think it's a very important, significant move in the law. As Mr. Atrey was saying it some time ago, that this can be questioned and challenged in a court of law because, after all, it is undermining the fundamental rights of a citizen. But I think there is another provision in these the director's powers, which I think needs to be discussed and debated, which, in my view, is that you are setting deadlines for everything here. You are saying the law that you attach a property, you do it for 30 days, and within that, within 6 weeks, the special court sits and hears it, and then there is no closure in line. 180 days, it can be extended again.
Yes.
Now the question is that in the insolvency and the bankruptcy code, there is a closure thing given.
Yes.
180 days, everything should be closed. Now I would have expected that since it is a law that is aimed at bringing about closure of these cases, if you keep it open-ended, that it will be extended after 180 days, another 180 days, goes on for 1 year, 2 years.
Now, so it is again one of the non-ending.
So therefore, like the IBC has put in itself a clear closure date, I would have been very happy to see a closure that after 180 days, it has to be closed, or maybe give only one extension and then it is closed. So that I would like to make this point here.
Dr. Atrey, would you like to add to that?
See, another aspect by which we can see this act. If a person is declared fugitive offender is the person who is not surrendering himself before a court. That's the only aspect, that's the only offence under this act. He is not surrendering.
Correct.
And he is declared fugitive offender. Once he is declared fugitive offender under 12(1), thereafter special court next order will pass that all his property shall be confiscated. His only offence is he has not appeared. And once his properties are confiscated, government has all powers, free from all encumbrances, they can dispose of. And he has no right to reclaim his properties even after he comes back, even after he proves himself not guilty in any court in the main offence for which these proceedings started. He has no right over his properties. So the powers of government are so wide in this, and the powers he cannot claim his civil rights. The bar on civil rights, it's changed in Indian legislation. We have not seen such kind of provisions anywhere.
But Dr. Atrey, but this is an attempt to create a compelling environment for these fugitives and people who've run away with 12,000, 13,000 crores, 50,000, big amounts of money, people's money. So there has to be an exception.
Idea is very good. I am not claiming the idea behind this.
It will come into conflict with the other rights.
Yes, with the other rights.
Got it.
Accused are also human beings. They also have certain fundamental rights. They have a fundamental right to defend their case.
So the larger
defend their case.
rights can't be compromised for
Can't be compromised.
achieving small goals. That's
Yes,
what you're
yeah,
trying to say. Okay.
The other point I would like to make is in this director's powers is about the contracting parties, you know.
Yeah, that's the point I was coming
Yeah.
to. So about the contracting parties, so India and abroad is the word used in the proposed law, that all properties, whether in India or abroad, how are they going to do it if it is abroad? What is required for the Indian agencies to attach property that is abroad?
See, the provision is subject to India's having relevant treaties with those countries. Now, if let us say economic fugitive offender is residing in a country and its assets are in a country with which the government of India doesn't have the relevant treaties by which it can enforce its laws, then my sense is that the efficacy of this law will be limited to that extent. So therefore, this is a provision that may have a kind of a demonstrative effect on the government's other arms to conclude these treaties with different countries.
Correct. So basically,
so that it can be enforced.
So, Mr. Bhattacharya, so the point is that this bill then goes on to provide the enabling legal framework for the Indian government to get into these treaties. And that will be the next big step that the government of India will have to take and negotiate and get it done.
Absolutely.
You want to add to that, sir?
Yes. Government has to do treaties, and the other thing, even when there are treaties, we seen in the past the several governments in different countries don't cooperate even after treaties. So that's a second issue we have to face in future. Like Vijay Mallya, you can't think that he will be given such priority in England.
And also on the point of the Benami transactions, you had a point to make. So the Benami transactions, how do you really rein in the Benami transaction or the Benami properties that are there? How do you go about attaching that? That also needs to be clarified. So what is the law clear on that?
As is clear from the Benami transaction, Benami property is not in the name of that person. It may be in the name of his servant, it may be in the name of his manager. People generally don't keep it in the name of any of his family members.
Yeah.
So when it is in the name of any other person under Benami Transaction Act, he has a right to own that property, disowning all rights of the person who invested that money. But here, under if it comes in the notice that this is a Benami property, maybe in the name of any other person, it can also be attached, it can also be confiscated. So the scope is there to enlarge powers up to that property, and suppose the property is in the name of 3-4 persons jointly. All other persons' properties can be attached and confiscated. If it is found, it is proceeds of crime.
So proceeds of crime, just trying to split it, does it also happen that if the family members have a lot of property in their name, so but it's not specifically mentioned here. Benami property is which is outside the family ambit, according to the definition. So what happens to the properties of
the law is very clear in this. The law
that
says
also goes
that the burden of proof that it actually is the money that is come from the proceed from the crime, which is in this case the Benami law, has to be established by the director. So the burden of the proof rests with the director,
prosecuting
agency. Please remember, the burden of proof, along with the burden of proof, the director also has the right to conduct surveys, conduct searches,
all the powers,
conduct seizures.
Yeah.
So he has the powers, but also the burden of proof lies with him, and his decision can be challenged in High Court.
Correct.
So all those safeguards are all there.
Already there.
Yeah.
Quickly.
Regarding burden of proof, one important thing, interesting thing which is in this act. See, there are two parallel jurisdictions in any legislative framework: criminal jurisdiction and civil jurisdiction. All these acts, all the offences mentioned in the schedules are criminal offences. And when we conduct trial of criminal offence, the criteria for burden of proof is beyond reasonable doubt. The burden on the prosecuting agency is always to prove their case beyond reasonable doubt against the person who is accused. Now here it happens only in civil cases that preponderance of probabilities. This is the criteria which is fixed here. It is criteria for civil wrongs. not for criminal wrongs.
Got it, got it, got it.
And it is very lesser.
Dr. Atrey, we've run out of time. It's a very interesting debate. I would have gone on and on it, but I think we've short of time. So thank you, Dr. Atrey and Mr. Bhattacharya, for joining us on this discussion. It's time for us to end the show. You can watch our shows on the RSTV page of YouTube. We'll be back with a new issue and a new episode. Keep watching Rajya Sabha TV.